Good afternoon, everyone, and welcome to our webinar on understanding FDS and opt-in obligations. We will get underway very shortly. We've got people joining at the moment, so we might just give them a couple more minutes before we get underway. Yes, we're up to 42, so yeah, 66. So we have a number of people who have joined us, and thank you very much for participating in the webinar today. I think the background on this is that over the years we do get questions from time to time about opt-in and FDSs, and we did get a sense that maybe there was not a full understanding of this. So it's something that we've been thinking about. We do answer questions on a regular basis to help people with this, but we thought that a webinar would be a good way to move forward. Now, the actual reality is that ASIC have come out very recently with an announcement on this. Now, it comes off the back of all the work that they're doing on fee for no service, which has been a huge issue that's been, I guess, emerging over the last 2 or 3 years, and it became a really big focus of the Royal Commission, where there was a lot of discussion around different entities that had fee for no service issues, and we've seen some very large numbers reported more recently in terms of remediation on that. So ASIC have now moved on to not so much a matter of whether services were not being provided for those fees, but whether the advisor had been meeting their obligations with respect to opt-in and fee disclosure statements. And it is really important because a failure to meet those obligations can actually terminate the ongoing fee arrangement, and the consequences of that are particularly important. So on the 12th of October, they made this announcement. They've highlighted the fact that they are going to be running a sizable project on this, and it's been driven off the fact that they've received a number of breach reports over recent times, suggesting that people have had problems with opt-in or fee disclosure statements and not meeting their obligations. So if we have a look at what they've said they're going to do, they're going to have a very good look at whether people are issuing FDSs and renewal notices to customers, and also whether they're doing it within the timeframes set by the law. And we'll talk in a moment about what those timeframes are, but this is really important because a failure to do it within the timeframe can make it an invalid opt-in or an invalid FDS. Now, they'll also be focusing upon whether you've met your obligations in terms of the content of an FDS, and ensuring that the content is accurate also. I mean, you can't say things in an FDS that you can't back up. And also, the last thing is have appropriate procedures in place to ensure that fees for ongoing service are discontinued when the arrangements are terminated as a result of the failure to meet those obligations. Now, we're going to cover all of this today. And I think it's really important that we do this in a sensible, systematic way. And as we go along, I'm very much going to welcome questions on this, and we will pause from time to time. I've got Connor and Mark and Mel with me from the AFA team, and I'm going to invite them to come back to me with any questions so that we can make sure that people are following this discussion. I will say at the outset that this is a fairly technical, complex area, and we do need to make sure that people take the time to understand it. So that's what we understand. That's what ASIC are going to be looking at. What I'm going to do to start with is just take you back through the law so that everyone has a good sense of what the law actually requires. Now, in looking at this, we're going to make sure that you understand the terms. Now, we're going to be using terms today. We're going to talk about fee recipients. We're going to talk about ongoing fee arrangements. We're going to talk about renewal notices. So it's important that you understand the terms. One other really critical part of this is the definition of what a new client is. We've got existing clients, we've got new clients. The obligations differ significantly. For new clients, you need to do both opt-in and fee disclosure statements. For existing clients, you only need to do fee disclosure statements. So we'll look at that definition carefully. We're also going to focus upon understanding the content, understanding the maximum timeframes, and then understanding what we need to do if something goes wrong. So let's have a look to start with at the definition of an ongoing fee arrangement. Now, this is a really critical definition because this is what the whole obligations around opt-in and fee disclosure statements apply with respect to. Now, the reference there is section 962A of the Corporations Act, and we'll come back to a focus on where the key reference points are. But if you have a look at this, an ongoing fee arrangement is a situation where a licensee or representative provides personal advice to a retail client. Now, that personal advice to a retail client is a relevant point when we look at corporate super, where personal advice often is not provided. So the first leg is it's got to be personal advice to a retail client. They've got to enter into an arrangement with the licensee or the representative, and that arrangement needs to be for a period of more than 12 months. Now, this is also really important because it is possible to set up arrangements for less than 12 months. Now, I want to just take you through also some other things that are excluded. So if the only payment that is paid under this arrangement is with respect to a premium for life insurance, then it is excluded. So where the only arrangement is a life insurance premium and that the advisor is being paid commissions as a result of that, that does not actually qualify as an ongoing fee arrangement, which means that opt-in and FDS are not required. Also in the case of commissions, trail commissions for existing superannuation and investment business, a trail commission is not classified as an ongoing fee arrangement. So we might ask, how do you actually define what an ongoing fee arrangement is? Well, it's where the fee is actually paid by the client rather than the product provider. And it might be that one way of thinking about that is the question of whether units are being redeemed out of the client's account in order to pay those fees. So if they're not, then more than likely you're looking at a situation where whatever fees you're receiving are actually commissions or trail commissions. So that's the definition of an ongoing fee arrangement. This is critical because it defines whether you're actually caught by the opt-in or FDS obligations. Now, this particular slide, I'm getting really technical here. This is a critical piece of the legislation, section 962D, and I have to say it is one of the most complexly worded parts of the legislation, and you need to read this and reread it to make sense. So I'm going to take you through very slowly. Now, this refers to a particular subdivision of the Corporations Act, which is the section that relates to opt-in and FDS for new clients. So it excludes existing clients. It is with respect to new clients. So the client has not been, so noted the word not been provided with personal advice as a retail client before the application day. Now, they then go in to talk about this being provided by the licensee or a representative of the licensee. So if they have not been provided with personal advice before the start of FOFA and the client enters into an ongoing fee arrangement on or after the 1st of July 2013, then they are a new client. So you can look at this in terms of if they received advice before the 1st of July 2013, then they are not a new client. Now I'm going to come back and explain the importance of that second part later on when we talk about the implications of the sale or the purchase of a business or a book of clients. So that definition of existing client is really important. Now, I welcome any questions that there might be with respect to these definitions, and I'll call on the guys as any questions come through. Okay, dates are also really important. So that The terms here are the renewal notice day. Now, the renewal notice day is the opt-in day. The law talks about renewal notices. We refer to it as opt-in. So we've got to use those two terms interchangeably. Renewal notice is the same as opt-in. And then there's also a disclosure day, which is the day that applies for fee disclosure statements. So there's two separate days. Now, the renewal notice day is the second anniversary of the day when the arrangement first started. Now, the day that it first started can typically be the day that the client signed the authority to proceed. So for a new client, it is the second anniversary of the day they started the arrangement. From that point onwards, it is the second anniversary of the day on which the arrangement was last renewed. So the last day, the last time that the opt-in notice was signed by the client. Now, the practical reality of that is it means that it's not exactly 2 years apart. We'll come back to the potential implications of that later on. Now, the renewal period is another key definition in the legislation. It refers to the 30-day period after the issue of a renewal notice or an opt-in notice that a client has to respond. Now, disclosure day is with reference to fee disclosure statements, and that is the anniversary of the day on which the arrangement was entered into, i.e. the authority to proceed was signed, or the anniversary of the day immediately after the end of the previous FDS period. Now, we'll come back to some examples in just a moment so that we can ensure that people genuinely understand those different dates and the different provisions there. Okay, so let's have a look at the opt-in obligations. Now, we'll do this from the start. So it's something that you have to provide every second year. Now, the fee recipient, the advisor, must, within 60 days of that renewal notice day, give the client a renewal notice, an opt-in notice, but they also must give them an FDS. The legislation is very clear. It's not just a matter of giving them an opt-in notice. And in fact, if you don't give them the FDS with the opt-in notice, then you're not validly complying with the legislation. Now, I think the rationale for that is that the FDS shows the client what they have paid over the last 12 months, and that gives them the basis then to make the decision as to whether they want to opt in and continue for the next 2 years. Now, along with that core part of the renewal or opt-in notice, there are some key legislative requirements that you need to include in your renewal notice. So it's really important that you make sure that your renewal notice is compliant. Now, this is quite technical, and what it's doing is making sure that the client really does understand the basis of the decision they're making. So a statement that the client may renew the arrangement by providing notice in writing. A statement that the arrangement will terminate if the client does not elect to renew. Now, that's where they actually specifically decide not to renew. A statement that the client will be taken to have elected not to renew if they do not respond by the end of the renewal period. Now, we talked earlier on that renewal period is a period of 30 days. A statement that the renewal period is a period of 30 days, as we said, beginning on the day the renewal notice and FDS were given to the client. Now, we're going to come back and we're going to give some examples that might help to explain that. Now, I might just quickly refer to Connor and Mark. Have we got any questions?
Yeah, we've got one come through, Phil. So the FDS and opt-in arrangement date should be the authority to proceed date, not the date of which the ongoing fee began.
Yeah, that is a good question, and there is some flexibility. So if there was a period of time between the fees actually starting and the arrangement being put in place, I certainly think that there's provision for you to use one or the other, but in what you do, you have to be consistent. So you need to ensure that if you're using the authority to proceed date, then you're using that for all clients. If you're using another date, which is, I really think the only other option is the day that the actual product gets put in place, then you've got to use that consistently.
There's another two questions. The first is, does written confirmation of renewal notice include via email?
Yes, it does. So the law is was quite open about how opt-in may be done. Now, I think a number of licensees actually prefer to see it as a signature on a page, but the law does not exclude it from being done via an email response. Any other question?
Yes, there's a similar question. Can the opt-in be renewed by SMS and or via email? Does that constitute writing?
Yeah, so the interesting thing is, at the time of the FOFA legislation, there was a specific mention in some of the discussion by the government about using SMSs. Sorry, of using SMS. The critical thing though here is that you need to be able to document the evidence that shows that the client has responded. Now, an email can be included on the client file. If you're going to do it via an SMS or a text message, then you need to think about exactly how you can document that in a provable way on the client file, should you be subject to an audit later on. So I think and also in all of this, you've got to rely upon the standards that are set by your licensee.
Another question, Phil. We're currently using the super account start date as the start date of the ongoing fee arrangement. Is that not correct?
The super start date.
The super account start date as the start date of the ongoing fee arrangement.
Yeah, as I said before, that you can either use it as the date of the authority to proceed being signed or the actual product start date. So I think that's absolutely fine. But as I said, you've got to have a consistent approach and it's got to be adequately documented. So we'll come back to some key tips around how that needs to work going forward. All right, I might keep moving on. So some other key legislative provisions. Now, as it applies to opt-in, so a failure to meet your opt-in obligation or the FDS obligation this is for new clients, means that the arrangement is automatically terminated. So the law specifically says that if you don't issue your opt-in notices or your FDS notices, or you don't do them consistent with the law, and this might be because you don't meet the timeframes or you don't meet the content requirements, then it automatically results in the ongoing fee arrangement being terminated. If the client notifies that they do not wish to continue the arrangement, then the arrangement effectively terminates on the day that they give you that notice. Now, the other situation is you've sent the opt-in notice out and you don't hear back from the client. So the question is, what happens then? So at the end of the renewal period, which is 30 days after the provision of the opt-in and FDS notices, so the end of the renewal period, you've got a further 30 days in order to turn it off. Now, there's another key point here that as you get to the end and you terminate that ongoing fee arrangement, the law makes it clear that your obligations to provide continuing services also cease at that date. Right, let's talk about the FDS obligation. Now, the FDS obligation is an obligation on the advisor, and there's no requirement for the client to respond or even confirm receipt. You, however, need to have absolute evidence that you have provided the FDSs. Now, you have 60 days from the disclosure date to give the FDS to the client. Now, the FDS must contain the amount in dollars of ongoing fees paid under the arrangement in the previous year. Now, it may be that you will have multiple products with that individual client, and that fees will be taken out of each product. You'll need to document the total fees, and typically people will separate that into a figure per product. You also need to include in the FDS information about the services the client was entitled to receive in the previous year. And in addition, you've got the services that the client did receive. So from that, the client can see exactly how much they paid, what they are entitled to receive, what they did get, and therefore they have a sense of understanding of what they didn't get. Now, presumably for all of those scenarios we've seen where we've got fees for no service, then the FDSs would have disclosed an entitlement to receive services. However, the services were less than the entitlement. Now, importantly with FDSs, you are not required to disclose trail commission or insurance renewal or service commissions. Now, you're not required to, but you may choose to. And if you choose to, it's important that you disclose that clearly. That's a choice that you can make. Now, there are certain of the older products where there was provision for the advisor to receive a trail commission, and then they could dial that up. So technically, you would have a trail commission component and an ongoing advisor service fee component. And it would be a very problematic thing to include the ongoing advisor service fee, but to exclude the trail commission. There is complexity in this, and we'll talk a bit more about that in a moment. Okay, have we got any questions that you want to raise at this stage, Connor and Mark?
Yeah, Phil, we do. So,
yeah, so a couple of questions have come through. The first one is, Clem has a concern that if you provide no new advice, i.e. review declined or no need for further advice in 1 year, as an example, ASIC expects the entire fee to be refunded, which ignores any admin servicing delivered. If the legislation states that the ongoing fee arrangement applies only where personal advice is delivered, does that mean that you can charge a separate admin servicing fee that does not have ongoing fee arrangements required?
Look, I think that's a good question. ASIC have also recently put out information sheet 232, which talks to their remediation expectations with respect to ongoing fee arrangements. Now this is about the issue of fee for no service. Now, ASIC have set this out, and in our discussions with ASIC, they have clarified it a bit and said that this is what they would expect in the context of a remediation project. Now, it may be that you are providing services, maybe it's not every year. Now, the example they gave us was you provided it in 4 out of 5 years. That does not necessarily terminate the arrangement. So there needs to be a little bit more flexibility in this, but information sheet 232 was very blunt, and it really did suggest quite clearly that if you had not provided your review every year, then they would consider that you have not provided the committed services. I think the other really important thing that this comes back to is just having a look at your service packages. What exactly are you committing to provide each year, and how clearly has that been worded? Is there any room for confusion or ambiguity? And are you actually able to deliver to those service packages? So I think it's a really important exercise to go through and just have a look at how your service package commitments actually line up with the services that you do provide to clients. Now, that's a question with respect to that information sheet 232, which was not really the core purpose of the session today. This is about the practicalities of what you need to do with meeting your opt-in and FDS obligations. But if there's further questions on that, we can deal with them at the end of the session. Any more questions?
Yes, there's been a couple of questions that have come up around the 60-day period to send an opt-in and the 30-day notice period. Perhaps Phil, do you want to just explain that again?
Okay. So the time frame that you have to, and we're going to go through this example here, which is probably going to help explain it. So the 60 days applies in terms of from the end of the previous period, so the fee disclosure period, you have 60 days to issue the FDS. You also have 60 days from the renewal date to issue the opt-in. The 30 days applies with respect to how long a client has to respond to an opt-in or renewal notice. So the difference is the 60 days is how long you have to get them to your clients. The 30 days is how long the client has to respond to an opt-in notice.
If the agreement says clients are entitled to receive, say, a personal review, but they decline to attend, is this a problem?
So the ASIC have provided some guidance on this, and they've made it clear that you need to not only make the offer, but you need to document that you've made the offer and document the response. They've talked about if you don't get a response, then you need to try more than once. But clearly, if the client has said they don't wish to do a review, then how can you be bound to do any more? I think it's really important that in that process that you document to them, you send them a letter saying we've offered you a review, you've declined the review. Please don't hesitate to contact me, and you might provide them with a few other bits of information that's relevant. I think if you've got that documentation on the file, that it's supportable. You can't actually physically force a client to come into the office if they don't want to, and it may be that that for them it makes more sense to catch up with you every second year. Once again, go back and have a look at that service package to make sure that it does align with the way you're operating your business and the needs of your clients.
And one more, just quickly, Phil, going back to the SMS opt-in question, would a screenshot of the SMS saved to the client file be sufficient?
Look, I'm not really in a position to answer that question because it depends upon the view that ASIC might take when they come to look at it. I will make the point at the end that ASIC actually haven't provided any regulatory guidance on opt-in, so it is a bit of a grey space. But you know, if you've got that proof, you've taken a record of it, you've got it on the client file. Now, at the end of the day, if it came to it, you could probably get the telecommunication provider to demonstrate the proof for you. Okay, let's keep pushing through with this example. So the scenario here is a new ongoing fee arrangement kicks off from the 1st of September 2015. And as we've said previously, this could be the day that they sign the ATP, or it could be the day that the product actually starts. That is the day that you've defined as your ongoing fee arrangement commencement date. Okay, so 12 months on is your disclosure day one. So the 1st of September 2016 is you reach the end of the first year. Now you must issue an FDS. Now this is a new client, so they're a post 1 July 2013 client, and so both FDS and opt-in will apply. So at the end of the first year, you've got to issue the FDS. You've got 60 days to issue that to them. So you've got till the 30th of October. That date should be the 2016, my apologies. So you've got until the 30th of October 2016 to issue that FDS. And it will cover the period, the 1st of September 2015 to the 31st of August 2016. So that's your first year. Your only obligation in the first year is an FDS. At the end of the second year, and your renewal notice day 1 and your disclosure day 2 is the 1st of September 2017. So this is the second anniversary, at which point you need to do both FDS and opt-in. So you then have until the 30th of October 2017, so 60 days after that renewal notice day and disclosure day, to issue both the opt-in notice and the FDS. Now the client has 60 days in order to respond to that opt-in notice. Now they've got 30 days in order to respond to that opt-in notice. That 30 days takes you until the 29th of November 2017. Now that's assuming that you issued the opt-in notice on the last day of the 60-day period, and they then have a further 30 days to respond. So that takes you all the way to the 29th of November 2017. If the client has not responded by the end of the 29th of November 2017, then you have to terminate the fees 30 days afterwards, which is the 29th of December 2017. Now, I just take a few examples. If you issued your opt-in and FDS on the 31st of October 2017, it would be 1 day late and non-compliant. The law is not obliging in that. It is very clear that is non-compliant. If the client did not respond until the 30th of November, equally, that is non-compliant. It's 31 days, and it would technically mean that you have to terminate the arrangement. Now, the interesting thing coming off this is we've talked about the 29th of November 2017 as being the final date. Now, that's the date that the client must sign by. So they must sign the opt-in by the 29th of November. If they sign it on the 29th of November 2017, then the second renewal date, which is 4 years after the commencement of the arrangement, will be the 29th of November 2019. But notice here that because the renewal date is the second anniversary of the date the last renewal notice was signed, there's a drifting apart of the renewal notice day and the disclosure day, because the disclosure day stays the 1st of September. Appreciate there's some complexity with that, but I hope the example gives you some sort of context as to how this plays out in the first 2 years of a client relationship. Now, I want to just talk about FDS for existing clients. Now, existing clients, as we said, and we'll go back to that definition again, an existing client is someone who was a client before the 1st of July 2013. Now, there is one really key difference. Other than the fact that you don't have to provide opt-in for existing clients, the other key difference is that if you fail to meet your FDS obligation to existing clients, it does not include that clause that meant an automatic termination of the ongoing fee arrangement. Now, that in itself is potentially some benefit because you're not actually forced to start a new arrangement in that case. However, it does not remove the fact that technically a breach of that obligation is still a civil penalty provision. It's an important consideration when thinking about remediation of clients caught in this situation. Okay, I just want to also cover for people, and I think this is something that a lot of people have this understanding of this potted history of the FDS obligation for existing clients. I want to take you through this because it is really important that people are absolutely clear on the requirement to provide FDSs to existing clients. So when the FOFA laws first started, ASIC came out and said they would take a facility of compliance approach for the first 12 months. And that meant as long as you could demonstrate that you were taking reasonable efforts to meet your obligations, they would not come down hard on you. It got a little bit complex though. At the end of December 2013, the government, the Liberal government at that time, announced a package of reforms to FOFA, which included the removal of opt-in and the removal of fee disclosure statements for existing clients. Now, ASIC immediately came out and made an announcement that they would take no action with respect to people who were relying upon the government's commitment to change the law. Now, we had that period through 2014 where there was a great deal of uncertainty and whether the law would get passed and whether the provisions that were enacted through regulations would be disallowed. There were, I think, 3 votes, and the last of those 3 votes was on the 19th of November 2014 when the FOFA amendments regulations were disallowed. And ASIC came out once again and said, and particularly referred to fee disclosure statements, that they would take a facilitative approach until the 1st of July 2015. So this meant that during this period, in many cases, FDSs were not being provided to existing clients, but ASIC had given a clear notice that they weren't going to take action against advisors who had breached those obligations. Now that all changed, and from the 1st of July 2015, there should be absolutely no doubt that FDSs do need to be provided to existing clients. So yes, there has been this potted history, but everyone should be in no doubt that FDSs apply to all clients who are on ongoing fee arrangements. Okay, let's have a look at what should you do if you make a mistake. So this is about responding to an opt-in FDS mistake. Now, I'm going to primarily focus on new, post 1 July 2013 clients. Now, a mistake may be that you haven't done your FDS, or you haven't done your opt-in, or you've done it late, or you've discovered that you didn't include the material that you needed to include in it. The law is really clear. The arrangement effectively terminated the day that you failed to meet your obligation, and you were required to cancel the fee arrangement immediately. Now, I think there's no doubt that ASIC will expect you to refund the fees back to the time that the error was made. So what do you do about it? Well, what you need to do is immediately seek to commence a new arrangement with that client. Now, you're going to do that either by providing them with a statement of advice or a new letter of engagement. And that will need to clearly set out the basis of the arrangement, the fees that you will receive, the services that you will provide. And I think it's really important to get a client's signature on that to make sure that it stacks up. Now, when you do this, you have in effect put in place a new arrangement. Now, in doing a new arrangement, there are potential other consequences, including, in certain circumstances, opt-in, which I'll come back to, but it also changes the dates. So you have a new commencement date and you will have new opt-in and disclosure dates from that point forward. Are there any questions?
I feel there's a lot of questions that have come through, so we might just leave those through to the end of the presentation.
Okay, all right. So we will hopefully have time at the end to cover off some of the questions. It may be that some of the questions are going to be answered by the next section. We'll certainly take on board these questions, and it may be necessary for us to provide more guidance. It's fantastic that we're getting so many questions, and it's great to have such a big audience on the line for this session. All right, so I'm going to move on to a couple of applied issues that it's really worth understanding the consequences, because, as I said, this is complex stuff, and there are different complex situations that you need to appreciate. Okay, so you've purchased a business or a book of clients. What are the consequences in terms of opt-in and FDS? The practical reality is that certainly with the purchase of a business, it's business as usual, and all the obligations of that business continues. If you've purchased a book of clients, then in effect what's happened is you have had the rights of that arrangement assigned to you. And you're basically stepping into the shoes of the previous advisor, which means that you have to meet your opt-in obligations and your FDS obligations as though you were the previous advisor. So if you purchased a client and they had had 6 months of service under the previous advisor and 6 months of service under you as the new advisor, your FDS needs to cover the fees that were earned in that full 12-month period, only half of which you benefited from, and also the services that were provided in both the 6 months that was the previous advisor and the 6 months where you were the advisor. So this means it's absolutely critical when you purchase a book of clients or you purchase a business that you get all the records that you need to meet your FDS obligations. So you need to know what fees were paid from the date of the previous FDS through to the date of acquisition, and you need to be able to add that together with the fees that you earned for the remainder of the period. And you also need to have all that information in terms of services that were actually provided. This really means that due diligence exercise that you go through with the purchase of a book of clients needs to have a particular focus on making sure that you get everything you need to meet your FDS obligation. Now, if the client is an existing client, in that they're a pre-1 July 2013 client, and you purchase that book of clients, then they can and do remain an existing arrangement, and opt-in should not be required. But what I want to do is just take you back to that particularly difficult piece of legislation, 962D, which talked about the definition of a new client. If I go back through this, the client has not been provided with personal advice as a retail client before the commencement date by either the licensee or the representative. So if it's the same licensee, then you may still comply with this requirement. If it's a change of advisor within the practice, and then you may see that it's actually the corporate authorised representative that's the consistent. However, where it's the purchase of a book of clients and it's from one licensee to another licensee, it's actually Part B of this that provides the protection that enables you to continue to treat them as an existing client. Because you have not entered into a new ongoing fee arrangement, you have continued the existing ongoing fee arrangement from the advisor that you purchased the client book from. So that means that they can continue to be treated as an existing client. But just keep in mind that because you have not provided advice to this client before the 1st of July 2013, should you put a new ongoing fee arrangement in place, whether that means there's something material that changes in the arrangement or you need to do it because you have somehow failed to meet your FDS or opt-in, your FDS obligations, then they will become a new client and you will need to meet your opt-in obligations. I appreciate this is particularly technical, but the point here is that if you have purchased a book of clients and you did not provide advice to them before the 1st of July 2013 and you're in a different license, they remain existing clients until you enter an ongoing fee arrangement after the date of acquisition. That's probably one of the most technical pieces of this, and I appreciate Section 962 is a really difficult piece of legislation to read and understand, but it is really important in understanding that difference between new and existing clients. Okay, next key question is, can I bring the FDS or opt-in forward? Now, the basis of this is that you might have clients who commence throughout the month at different days, and it might be administratively challenging to continue to maintain all these different FDS dates. So you might want to batch them all up. You might want to do them everyone on the same day every year, or you might want to do them on a quarterly basis. So can you move the FDS dates? And the reality is, yes, you can. You can bring the FDS date forward. You can also bring the renewal notice date forward. And if you wanted to, you could get clients to opt in every 6 months. God knows why you'd want to do that, but you could. So the practical reality is you can bring the dates forward, you cannot defer the dates. Now, where you bring the date forward for an FDS, you still need to cover a full 12-month period. Now, this may mean that there's a period under which you're disclosing information on fees and services provided that was included in the previous FDS. Now, we've got a diagram coming up that explains this better, but you are always providing an FDS that covers a 12-month period. Now, if you choose to bring forward the date in the first year, say the client comes on board on the 30th of September and you want opt-in, so you want the FDS to be done on the 1st of July of the next year, then it'll be for less than that full 12-month period. And that just needs to be explained in the FDS. Bringing forward the opt-in or FDS dates resets the dates for future times. However, resetting the FDS date does not impact the renewal date. And I'm going to talk about an example for that in just a moment. They are separate things. So every time you reset the FDS date, it does not mean that it changes the renewal date. So let's have a look at this example of a bring forward proposition. So you've got a client, as I said, kicked off on the 1st of September 2015, but you want to do FDSs that covers a full financial year. So you want to bring it forward, to bring forward the FDS date effectively to the 1st of July 2016. Now, if you're going to have an FDS that covers the period 1 July 2015 to 30 June 2016, then you have till the 29th of August 2016 to do that. Now, what that means is that your second disclosure day changes, and it's now the 1st of July 2017. So that facilitates the bringing it forward. But keep in mind that your renewal notice day will still be 2 years after the anniversary of the commencement of the arrangement. So that would be the 1st of September 2017. The practicality, though, is in that second year, if you're going to do the FDS to that disclosure date of the 1st of July 2017, then you're going to have to bring your opt-in forward as well. So you would have to do the period, the 1st of July 2016 to the 30th of June 2017, and you would have to issue the FDS and the opt-in by the 29th of August 2017. Now, the practical reality is that you've got to align them, and unless you want to do 3 FDSs in that first 2-year period, then this is the only practical solution. Now, the next slide, I think, helps to demonstrate this. As we said, arrangement starts on the 1st of September 2015. We've got the first anniversary, 1st of September 2016. But in this case, what we're doing is we're changing the second year. So what we're doing here is we're bringing forward the FDS for the second year. And in this case, we're bringing it forward to the 28th of February. So you will, in effect, in delivering that second FDS, you'll still be doing it for a 12-month period, but it will cover part of the period that you provided in your first FDS. In each case, you'll have 60 days to issue it. But the point here is that your renewal date will be the 1st of September 2017. Now, you either have to do another FDS on the 1st of September 2017, or you'll bring forward the first renewal notice and issue it with the FDS after the 28th of February 2017. Once again, this is a complex issue, but the important point to make is that if you bring the FDS forward, then you might have a duplicate period under which you need to cover a period that was in a previous FDS, and there will be a consequence for your renewal date. Is there any questions that we've got at that point that might be useful?
I think we should address all the questions at the end, Phil. We've got 21 open questions.
All right. Well, we are doing, we're doing well getting so many questions. I appreciate that. All right, we are pretty close to the end before we roll into the questions. So, can I avoid doing opt-in? Now, there are some absolute optimists out there who think it's possible to avoid it. So let me just set down the scenarios. If you only put in place an agreement that is maxed out at 12 months and in effect it terminates at the 12-month point, then you don't need to do opt-in or FDSs. You've only committed to a 12-month period, not over 12 months, so therefore it is not an ongoing fee arrangement. So if you do that every year and the period is always less than 12 months and they sign every year, then it is not an ongoing fee arrangement and you would not need to do FDSs or opt-in. Now, people are also aware that there is a provision within the law that says that an advisor who's bound by a code of conduct that obviates the need to do opt-in does not need to do opt-in. The only complication there is that the code that provides that obviates the need requires you to do a renewal. Now it's slightly different terms, and it's a 3-year arrangement rather than every 2 years. But you are still required to get your clients to renew their arrangements. Now the FPA has one of those codes. There's been a very small take-up of it, so there's 11 people currently signed up for that code. The AFA did not proceed down this course because we did not think that it was of benefit to members and that there wasn't really appetite to try and avoid the law by doing something under a code. But I think it's important that people are aware of that, and there may be questions that we can address later on. So some key tips. Be very careful in managing renewal and disclosure dates. You absolutely need to know those dates and they need to be right. If you use the wrong date, if something goes wrong and you use the wrong date, then that could mean you're automatically going to fail to meet your obligations. You need to have industrial strength processes. Now, leveraging your financial planning system is important, but you need to have office processes that ensure you stay out of trouble. With opt-in, track it really carefully. You've got 30 days to get them to sign. There's no time to waste. It often makes much better sense to do it face-to-face, and if you can lock in the meetings with the clients to ensure that you know exactly when you'll have the FDS and opt-in ready to sign, you get them in the office, you get to do it right there in front of you. Now, it makes really good sense to go back and do some checking from time to time. Make sure that you've got your dates right, your FDSs stack up, you've got your opt-in done, the content is right. So in a larger practice, I'd strongly recommend that there is checking that's done from time to time. Make sure you disclose everything correctly. Don't mislead the client by saying stuff that you didn't. If you can't prove it, then don't say it. Now there are going to be situations where there's additional complexity. You might have multiple accounts, the husband and wife, or the client and an SMSF. It is possible to do them together, but you need to make sure that the dates line up. We talked earlier on about dial-up arrangements and the complexity with having both commissions and ongoing fee arrangements for the same product. So key references. Now, I hope I haven't scared you too much away from looking at the Corporations Act. all of this is covered in Part 7.7a, Division 3, ongoing fees to clients. It's sections 962 to 962S. ASIC have also produced Regulatory Guide 245 on fee disclosure statements. Certainly recommend that. Unfortunately, they haven't done anything similar for opt-in, but what it does do is 245 is a really useful place to start. Now, we're going to go now to have a look at the questions. Let's see how we go at getting through them. We don't have that much time left, but we may be able to do a Q&A pack at the end of this for any questions that we don't get to answer. So over to you guys. Happy to have a little bit of time on questions.
Thanks, Phil. If original opt-in was not provided in the correct time frame, but we have subsequently sent out the client and the client has agreed to renew, is that okay?
So the difficulty there is what have they agreed to renew? Because you necessarily need to put in place a new arrangement. And if the client has just signed an opt-in notice, they have opted in to continue the previous arrangement. So it's not clear exactly what they're signed to continue with. I appreciate that's not the answer that you wanted, but you actually have to have a new ongoing fee arrangement that sets down what they are paying and what they're going to get for that. And that you'll see in an SOA, you'll see that in a terms of engagement letter. You just won't see it in an opt-in notice. So it's not the answer you wanted.
For the opt-in, if we have a husband and wife as clients, do both clients need to sign? Can they reply via email that they both accept it? If this is the case, how do we know that the husband is speaking on the wife's behalf?
So this is a difficult one because, and I come back to the point that there's no guidance on this. Ideally, you're treating them as one client, but it depends. I mean, if they've got two different products, then it may be that it makes better sense to treat them separately. And if it's going to be one signing for both, then if it was set up that way, if the advice was given to both of them, and they've signed it, it's taking a risk. I think the practical reality is it's taking a risk, and it would be better to mitigate that risk by getting the email to say, both my husband and I, or my wife and I, agree to continue the arrangement. The other thing is, look, I strongly recommend trying to align the dates to get the clients into the office to sign those documents in front of you.
Thanks, Phil. Another question here. If a client opts out, what are the obligations of the advisor if they still have insurance products? Is an annual review offer required?
So what you're saying is they've opted out of arrangements that are for superannuation or investment products, but they've held on to their insurance. So you can continue to service them. And the practical reality is that if you're continuing to be paid for servicing them as an insurance client, then we would normally expect you to continue to provide those services. But technically, it means that if the only product that's left is an insurance product, then FDS is not required, an opt-in is not required. The contract doesn't actually preclude you from continuing to be paid. But as I said, I think the community expectation is that services would continue to be provided.
Thanks, Phil. With regards to opt-in and changing licensees, does the change in licensee trigger opt-in for an existing client?
So a really good question. If it's the same advisor and they have moved licensee, then you go back to that definition in 962D, and it specifically says, if the client has received personal advice as a retail client from the advisor before the commencement date, then they are an existing client. So if it's the same advisor and they've moved licensee, then that's not a problem. And if it's the same corporate authorised representative, then it should not be a problem if it's the car that is the provider of the advice. I think that's probably answers that question.
Another question, Phil, is the client opt-in response 30-day deadline reset if the FDS and opt-in is issued as a reminder to the client?
Connor, can you just read that again?
Is the client opt-in response 30-day deadline, is that reset if the FDS and opt-in is issued as a reminder to the client?
No, I mean, the 30 days is there in substance. So from when you issue, they've got 30 days to respond. And so there is really nothing that you can do in that 30 days to extend it other than to get them, the only solution is to get them to sign.
What's the rules for issue of FDS if a client transfers to another advisor who provides the FDS?
So this comes back to the sale of a business or a book of clients. So we talked about that. The new advisor has the obligation to do the entire 12-month period, whether that's with, whether it'll cover a period with the old advisor and with the new advisor. If it's a change of advisor within a practice, then it's the same. You still need to do the FDS that covers that full 12-month period, and some of it may be with a previous advisor. If you read RG 245, it talks about assigning. It talks about a client being assigned from one advisor to another. Now, in effect, that doesn't change the contract. It's the same contract and the same obligations apply, but during the course of that 12 months, it was provided by different people.
In regards to FDS, if the client logs into a web-based individual portal, for example, the client's own portal with their own details, and that client views the fees and services provided in a separate tab, does this satisfy the FDS requirement?
Look, good question, and it's specifically referred to in RG 245 that ASIC specifically recognises the prospect of portals, and all you need to do is send an email to the client inviting them to log in and access their FDS, and that's fine. It's specifically referred to in 245. How are we going? We've got a few more there?
We do have a few more, Phil, and I think we'll have to answer the bulk of these questions by email after the webinar, but we might just try and knock off a couple more.
Yeah, sure.
So the next question is, if you have a pre-FOFA client with a different licensee, and then you change licensee and have to provide a new SOA where the ongoing arrangement in the body of the SOA, does this start a new arrangement?
Yeah, so the thing that sticks is if it's the same advisor, then it is the same advisor. If that advisor provided advice before the 1st of July 2013, even if they change licensee, even if they enter, if they establish a new ongoing fee arrangement, Section 962D still refers to the fact that they received advice from that advisor before the 1st of July 2013. So opt-in would not be required.
If an opt-in was sent out to the client before the opt-in renewal date and the client didn't sign within the 60 days, can we still charge fees based on the previous signed opt-in before the expiry?
So it's an interesting question, because what it's saying is we brought forward our opt-in and they didn't respond. So if that opt-in was issued with a fee disclosure statement and the client didn't meet their requirements, then I think it's a tall order to say it's good. We can continue through to the end of that 2-year anniversary. So no, I think that would be a high risk strategy.
How do we comply with providing FDS with opt-in if over years dates drift apart?
Yes, they do come back together, and the reason they come back together is because you have to issue an FDS with an opt-in notice. So when you do that, you're necessarily needing to at least partially align them again. So it means that you'll have longer to do your opt-in because the opt-in date gets adjusted to being the date the client renews. But the practicality is that you need to do the FDS on that precise annual time frame. So you're always going to be needing to bring the to bring the opt-in forward because the two have to happen at the same time.
Thanks, Phil.
We are a bit over time. Look, I very much appreciate everyone's participation in this. We will have a recording of this webinar. There'll be copies of the slides. We'll make them available. We'll look very closely at the questions to make sure that if there's any unanswered questions that we can get answers to people on. The other option is, by all means, get in touch with the AFA if you've got some particular questions that come out of this. I really do appreciate that this has been a technical session. It's been complex, but it's really important because things can go wrong in this space. And we know that ASIC is now looking at this very, very closely. So it is something that you absolutely need to be on top of. So thank you very much for your participation, and we will make materials available to those who have attended, and we'll also make it available on the website for others. So have a great day, and thank you for joining me.